Ladies and gentlemen, welcome to the Indie Zone. This is a very impromptu live that we are holding. There has been a major development in the lawsuit, the state lawsuit filed as Goncalves versus Washington State University. On January 27th, 2026, which is yesterday, the defense, Washington State University, who is represented by the Attorney General of the state of Washington, filed a notice of removal of the state lawsuit to federal court. Again, a removal notice was filed in Washington State Court, County of Skagit, removing the Washington State lawsuit, WSU lawsuit, that has been brought against them by Goncalves and the three other families of the students to federal court. There is no longer a case active in state court. Goncalves versus Washington State University will now proceed in federal court. I've gotten my hands on the removal notice, and I'm going to go ahead and I will read it to you. It's brief. It's just about 2.5 pages long. But we had thought that this might have been a possibility because of count 1 of the complaint. I have in a description to this live the link discussing count 1. That is the federal claim brought in state court under Title 9 federal statute. That is what the defense cited to in the removal paperwork. Again, breaking news. The state case is closed. The lawsuit is proceeding in federal court. That's Goncalves et al. Versus Washington State University. WSU is represented by the Attorney General of the state of Washington. The case has already been initiated. There's a federal case number. We have an episode of the podcast that we just published that goes into a little bit of detail as to what the heck just happened. But I'd like to, at this time, discuss the removal action. This action is now proceeding in the United States District Court, Western District of Washington in Seattle. Steve Goncalves, Karen Laramie, Jeffrey Kernodle, Stacy Chapin versus Washington State University, a public university. The federal court case number is number 226 CV 00301. The filing is called a notice of removal to federal court. And this is to the clerk of the above entitled case and to the attorneys for the plaintiffs. Please take notice that the defendant, Washington State University, WSU, hereby removes this case from the state court described below. It says here, this case alleges a violation of Title 9 of the Education Amendments of 1972, 20 U.S.C., and then when you see that squiggly mark, 1681, that's section. It's 20 United States Code, Section 1681, as well as state law claims. The state law claims were for negligence, but count 1 was the federal claim, Title 9. Plaintiff's complaint has not yet been answered by the defendant, WSU. So look for an answer. There's either going to be an answer in affirmative defenses where there could be counterclaims, where Mr. Kohberger could possibly be named as a third-party defendant. We don't know. This hasn't happened as of yet. Paragraph 2 discusses the fact that on January 7th, a complaint was filed. Superior Court of Washington for Skagit County gives the case number and all the parties. The complaint was served. That means a summons and a copy of the complaint was officially served on the defendant, Washington State University, by plaintiffs on January 7th. This notice of removal, it's timely. A notice of removal to federal court needs to be filed within 30 days, ladies and gentlemen, or they lose their opportunity to do so. Filed within 30 days of January 7th. It was filed yesterday, January 27th. And so this will now be. And the filing of the complaint alleging an action, again, pointing out 20 U.S.C. 1681 against WSU. And then paragraph 5, the plaintiff's alleged defendant WSU violated Title IX of the Education Federal Statute, civil action of which this court has original jurisdiction because they put a federal claim in there. And then paragraph number 2, which appears at page 3, reserves an immunity. The defendant WSU reserves all rights and defenses, and that includes possibly sovereign immunity. This notice is made without waiving any of those defenses that WSU may have. WSU will file copies of all process pleadings and orders served upon it within the 14-day deadline with the appropriate verification. This is dated the 27th day of January. Nicholas W. Brown, Attorney General, State of Washington, and then there's 2, it looks like, Assistant Attorney Generals who will be doing the work in this case. Jordan Jones, Connor Callahan. The address, they're out of Olympia, Washington, and it gives their contact information as they must do. So again, the state case closed. It doesn't exist anymore. It's been removed by the defense to federal court. And let's just see who's here today. Hi, William. Good to see you. Possibly a motion to dismiss might be next. We don't know. Hello to Wendy. And we have, hey, A.R. Hayes. Good morning. If anyone's not following A.R. Hayes, please do. He put up I just watched your new content last night, A.R., that you put up. Extraordinarily interesting. I found it very, very interesting. Thank you. I'm glad. Thanks, AR. Blue Devil, good to see you here. Beach Baby. Okay. Why does a defendant make a move like this? Why does a defendant make a move like this? Because somebody had asked, does this mean that they've settled? It does not mean they've settled. This is an indication that they're going to fight this and they're going to fight it aggressively. They don't want their Title IX funds suspended. And that's what has been in the first claim of that complaint. And like I said, if you'd like to learn a little bit more about Title I, that's the one that my eyeballs went to immediately. All of the other claims for negligence and everything else, I went to the first count, which was Title IX. And I thought to myself, geez, I wonder if they're going to remove this out of state court, because that claim is a federal statute. It's not a state statute. And remember, they didn't file this lawsuit in Pullman. They didn't file that. They filed this lawsuit where one of the plaintiffs live, where the Chapins live, in Skagit County, away from Pullman. So now what I think, and, just again, we're speaking here. I'm speculating. I don't know anything more than anyone else does. The respect that I have for you guys. Any one of you or I could have been on that jury. In Idaho versus Kohberger. You know a lot more than I think that you think you know. The reason why I think that they may have removed it as a strategy is to take this case out of the backyard where one of the victims lived, and that we've seen some of the horrendous pictures that came out just this past week. And there's a lot of emotion. And how could you not have a lot of emotion and sympathy for the children and for their family members and their loved ones? But hey, the law operates on the law. And, AR, your video, just, do they have the right person? Is it him alone? Is it him with someone else? Is it not him? Is it other people? We don't know. It seems like a lot's going on right now. We got this case that I've been covering very, very heavily. Please, if you haven't had an opportunity, we've got a playlist up. It gives you the shortcuts to everything. It's Hunter versus United States. And if Hunter gets his way, there could be additional grounds to challenge an appellate waiver like Mr. Kohberger signed that might make an appeal a lot more easier for him if he wishes to appeal. There's nothing right now that says that he wants to appeal. And I've spent a lot of my time looking at documents, looking at evidence. I have a big problem with the chain of custody of that chief. My opinion only. But there was, you have chain of custody to show that what you say you found at the crime scene is what you're saying you're testing over here. And there were 1,000 holes there, that could have really brought, is this the same item, into question. Okay, so we've got that. There's U.S. versus Hunter. Please listen. I'm going to throw out my 2 cents. Please listen to the oral argument before SCOTUS on the 3rd of March. It could change everything for not just Mr. Kohberger, but for everyone who signs away their appellate rights. I don't know when this became a thing, that when defendants negotiate plea deals, you know what they're giving up? They're giving up their 5th or 6th Amendment rights, right to remain silent, right to not be a witness against themselves, right to confront witnesses, right to put on their own defense against charges, all of the due process privileges. And what else? Oh, the big one, right to a trial in public, jury trial, where the other side, the government, who is accusing a person of these crimes, has to sustain their burden of proof. High evidentiary standard beyond a reasonable doubt that the person who's in the courtroom is the person you're saying did these crimes. Beyond a reasonable doubt. That, in theory, is a very high evidentiary standard. And then on top of it, you want them to waive all of their appellate rights too. That when you have a person like Mr. Kohberger, who was just diagnosed with some heavy-duty diagnoses, including autism, less than 90 days before, all of a sudden, all of this change behind closed doors happening. Now, all of a sudden, he's pleading guilty when you said he was factually innocent for over 2.5 years, and the public has been denied access to those documents, as we're supposed to be able to do, to make sure that our court systems are running the way that they should be. And I looked at that waiver questionnaire. He's crossing things out. He's saying yes, then he's saying no. He's saying he has all of these. There's no medical health practitioner who signed off on it that I saw that said that he knowingly and willingly, and that's what Judge Hippler needed to find, knowing and willingly signed this document. That is due process, guys. That is exactly what Mr. Hunter is arguing. He's arguing notice, but due process, 3 things. Notice, number 1, what the government's charging me with. Opportunity for me to be heard in a meaningful manner. And the big one, the oil that makes our country per the wishes of the 13 original colonies who demanded the Bill of Rights and then became the 13 original states, and the framers of the Constitution demanded in our founding documents, which is a fair and an impartial decision maker. Got that going on. And now all of a sudden, this WSU lawsuit, this WSU removal action, this tells me they're going to fight this. This tells me they're going to fight this case, and they're going to fight hard. And why defendants will remove a case to federal court is because the general thought across the board, it's not, but across, you ask anyone, you ask a law professor, you ask someone who's been through the criminal justice system, you ask an attorney, you ask somebody that studies criminal justice, federal court is generally thought to be more defense friendly than state court. State court, if you want to argue things emotionally, on emotions, people say, and again, this is what the general theory is out there. You want to argue on emotions, state court is great for you as plaintiff. You want to argue on the law, you want to be in federal court. So that indicates to me that they are very much going to fight. Do you think that they want their Title IX money messed with, they're coming after them. They're saying that they did illegal things under Title IX. They could lose all that federal money. And so they're going to want to fight that, I think. And that's one of the reasons why they removed, I think. Again, I'm speculating. I don't know. Just looking at what this is worded. But that removal paperwork has the first count all over it. It's just then it's, and then there's other state claims. But again, let's go back to Title IX again. No way if he didn't do it alone. Okay, Beach Babe is saying, my friend said, no way if he didn't do it alone would he take this rap, especially the kind, I don't know, it's so confusing. Hey, Lily, it's good to see you here. I hope your family's doing well. Central Florida Freedom is predicting that Kohberger will eventually be freed. Aloha, Richard, thank you for being here. So good to see you. So good to see you. Layla, okay, you started late trying to catch up. Okay. Oh, you're listening as you paint. Okay, continue painting. Hopefully you're painting something beautiful, or are you painting a house? Hello, William again. We've gotten several members of the channel who I greatly appreciate. All right, so for those of you who have just tuned in, big development in Goncalves et al. Versus Washington State University. Many of us have been waiting for the answer and affirmative defenses, or alternatively, for a defensive motion, because sometimes what a defendant will do is say, okay, let's see if we can get this thing dismissed out. Where the allegations here are so, they're so ambiguous, I need a more definite statement in order to respond. What they may turn around and do say, I'm going to predict right now, is that it is a pleading where all of the counts, all of the allegations are going with all of the counts. Sometimes they'll move for dismissal for that. Yeah, I heard that Mr. Blum has a new opinion. I see it as a positive that people are starting to question now and not, just jumping on the MSN bandwagon and just say, hey, we all know this was a horrible crime. We know that people need to be held accountable. We know that whoever did this, many people believe should face the DP. Capital case, no question. But what we're missing here, guys, we're missing the facts. This case was under seal from day one. And it's not just, I see people saying, oh, it's the, no, it's not just the state. The defense did their share in hiding this case from the public. It was Ann Taylor who drafted the first round of that gag order and went to Thompson, and they both convinced Judge Marshall to enter it day 4 of the case. And the defense is the one who started with the filing of things under seal. The evidence, they wanted all the evidence filed under seal. And not one of their motions to seal something from the public was ever denied. They never jumped up and down, the defense, and argued in favor of the First Amendment. Not until they felt like, when they remembered there was a First Amendment, they did it at the motions to suppress hearing. It's the first time I ever saw the defense ever raise the First Amendment, that something should be open to the public. When it suited them for 2 years, they filed motion after motion to seal. The state did the same. Sometimes they did things, the stipulations, the agreements, and then all the I never heard the defense, oh, we got to have this hearing open to the public. They never fought any of these closed hearings, and there were a lot. There were some that were never noticed until afterwards. The beginning of the case, there were a couple of hearings that Marshall held. The public had no notice that a hearing was even being had. So, we got this highly secretive case. Then we got U.S. versus Hunter saying that these plea deals are not good. The amicus, the people who came in, there's six amicus briefs. He's got a lot of support. And they're saying these plea deals that happened behind closed doors with the state and the defense negotiating things outside of the realm of the public. We don't know how the defendant is acting. And I just put up a presentation this morning from one of the amicus briefs that did a simulation of people who were not guilty of anything, but had pressure put upon them. And 52% of the people who did nothing wrong agreed to plead guilty. 52%. And that is a study that's in front of the justices of the Supreme Court right now as to why these plea deals, the organization that did that brief said these plea deals have got to go. It's more like we're a system of plea deals, not trials. When the heck did that ever happen? Ineffective. Yeah, Wendy's saying right now, ineffective a system of counsel is one. That's one of the couple of 2-3 grounds that you can raise to try to get around the waiver, the giving up of your appellate rights. But what Hunter's trying to do, they're trying to get due process in there. They get due process in there. Okay, his is for notice. What I'm saying is, does this man have the opportunity to maybe raise due process of unfair judge? I don't know how they went so quickly from guilty plea to sentencing. That usually takes months, and you got to have pre-sentencing things happen. Maybe somebody would have said, oh, wait a second here. This guy was just diagnosed with autism and all of these other, it's not like he's had it all his life, and he's been able to regulate his maybe vitamins or medications, take social skills training, do everything that people with autism do when they're diagnosed young. That's why they say early intervention is so important. Hitler looks at the form. You can see that the autistic handwriting. Hate to say that, but I know a lot. Got close people in my life who are autistic. They write just like Mr. Kohberger as adults, just like him, and people are calling him weird. And this lawsuit, I also have to raise the issue. This lawsuit raised the issue that people who are autistic are more prone to stalking. I'd like to see where that study is. Way to raise more discrimination, in my opinion, against the discrete and insular minority who is discriminated every day of the year. People with disabilities go through more. If you're in a wheelchair, if you're blind, if you're hearing disabled, if you have autism, before they even leave the house. And that is the only group where it's okay to slam them using these insensitive comments about them. Try and do that on the basis of religion or race or national origin. See how far that gets you to make a comment like that. People who are autistic are prone to stalking, which there never was any indication of him ever stalking. That was something that was raised in the affidavit of probable cause, and it has never gone away, even after the prosecutor stood up in open court and said there's no instance of him. And now it's in this lawsuit again. Okay, so the situation that we find ourselves in today is that this lawsuit is in federal court. There's a federal court case number that has been opened. I have it for you in the, I've done a presentation this morning on the podcast, gives you the case number. You'll be able to review the documents now in federal court on PACER, just like we're doing right now with, with the Schofield versus Guillard. This case is getting ready to go to trial on February 24th. That was filed in federal court as well. We go on to PACER. We get the documents. Everything is very easily seen. You can go ahead. You can file it's fascinating because we're going to be dealing with legal arguments here, more so in federal court. That's what typically happens. That's why they say if you're a plaintiff, you want to sue in state court. If you're a defendant, you want to defend in federal court. More formal, more procedures. So on, and how many, Rebecca is saying, I've been noticing now just how many cases end in plea deals. I never realized it before. I'm telling you, I knew that there were a lot of plea deals, Rebecca. And when I started to look into US v. Hunter, one of the amicus in favor of Mr. Hunter said, we become a country of plea deals. When did this happen? That's not what this country is built on. We're not a country of stuff behind closed doors. This stuff needs to happen in public. Everyone should have been, any one of us should have been able to go into that courtroom and watch the pretrial proceedings. That's why I've been calling it public trial, secret trial. You know, I started covering this case 2 years ago for the podcast, and it was like, yeah, we're going along. Oh, another motion to seal something. Oh, another motion to, another order sealing something. Not one of those 3 judges ever denied a motion to seal anything. Even after Hitler said back in January, remember when the media coalition got involved and said, hey, I told these guys they got to stop with the motions to seal. It's got to be the exception, not the rule. They got to give grounds. There's got to be legal grounds to seal something from the public. He never denied any further motion to seal anything, and he's continued to seal things even after the case. You tell me, this case has been closed for almost 6.5 months now. Why is it under seal to the extent that it is? Why has Judge Hitler stopped unsealing things? That third order that really starting to get into, I'm going to quote harsh and say the meat and potatoes of the case, where we're getting into the in limine filings in January, February, and March, excuse me, where all of the stuff, CSLI, a suspect vehicle 1, text messages, the use of the terms touch and contact DNA, the all of the stuff, all of the text messages inside of 1122, from 1122 outside, from 1122 inside, phone messages, all of the stuff that's been under seal from the motions in limine. Remember, motions, an application for a court order in limine pre-trial. Filing a motion in limine means that one side or the other was asking Hitler for a court order to either keep something out of the trial, this evidence, or keep it in. Motion in limine. That's the stuff that Judge Hitler said in the October 16th order. It's almost a month and a half since that third order came out, that he gave both sides the opportunity, give your objections or non-objections, why you want this kept in or out of the trial. All right, it's a month and a half ago. He renders his ruling December 18th. It's a month and a half since then. We haven't seen one document from January, February, and we haven't seen the fourth court order. That's when it's going to get really interesting, in my opinion, because that's when the stuff for the Franks hearing was filed. All of the motions to suppress evidence were filed, including the warrant affidavit, which is the affidavit of probable cause that was filed on December 29, 2022, 18 pages, page 18. Detective Brett Payne of the Moscow Police Department said, based on all the 18 pages before, Judge Marshall, we want you to find probable cause. We want a warrant for this man's arrest because he is responsible for the crimes at 1122 King Road. I'd like to see what the defense filed under seal to attack the warrant affidavit, to attack the warrants in Pennsylvania, to attack the warrants, to search his body, to search his apartment in Pullman, to search his car, SV1, right? That's what they're calling it, is SV1. They got all this stuff under seal from the public. What gives here? The public helped to pay for this case. And we got content creators that are trying to get out there and to get people like, Connor and Jules and so many other people who have tried to get stuff that they will not release to the public. And they're told, oh, you have to pay hundreds and thousands of dollars. Okay, well, how about you give me, Latah County, a discount for the tax dollars that every American who paid taxes in 2022, 3, 4, and 5 paid for your state case. There were dozens of federal employees that were working the state case from the first week. There was something like, they said 37 or so. All the technology that they use, like looking at suspect vehicle 1, who do you think paid for that? It wasn't Latah County. That came out of the American taxpayers. And we're getting ready to pay April 15th, again, another bunch of taxes, right? I don't know. Okay, am I breaking up at this time? Am I breaking up? Okay. So once again, I just wanted to get on here very quickly and just advise you that breaking news, the state case is in federal court, bottom line, because a notice of removal was filed from Washington State University yesterday. So we're going to continue to keep you posted as further developments arise. Please, if you haven't already subscribed to the channel, do so that you'll get notifications when we publish content that will explain to you every step of the way, backwards, forwards, up and down of what's going on in federal court right now. Okay. So make sure you hit the like if you like our content. Comments, pros, cons, whatever you feel, let us know. And we'll continue to keep you posted as further developments arise, guys. All right. I'm going to go because I really hadn't planned on being here today. I just wanted to share this breaking information with you. More to come. Stay tuned to the channel. Comment, like, subscribe. All right, guys. Until next time, this is Kathy. I'm signing out. We will see you soon. Have a great day, evening, morning, wherever you are. Bye now.